Mountain Road Summers, seeking the modification of special use permit for operations of farm winery, amending the conditions of approval regarding parking, food, music, and tents. Who's up? Okay.
And you have the map in front of you, and you did get, I emailed you the traffic study, correct?
Yes, I actually had a question on the traffic
I got hard
study.
copies today. Do you want one? Yeah. You don't want, so if you guys want to do this.
First question I had actually relates to the traffic study, so why don't I start with that and then we'll
Okay.
get on to the maps. When was the traffic study done?
Well, originally it was done last year, and then
Right.
we had it redone in November, or
No,
October. as I think
October,
it says.
okay. Because my concern with the traffic study is that you and Camp Iapo share the same road.
Up to, yeah.
Right. Well, I mean, in terms of getting there from town, right? I mean,
Sure.
Mountain Road is the path to both venues. And you're both sort of creatures of a warm weather business.
Okay.
And my concern is that the traffic study has been conducted kind of outside of yours and their peak seasons.
I think.
I was confused too. I just wanted clarification as to what it was updated. It says, like, on the second page, it says that it was the previously approved traffic assessment, impact assessment was updated to investigate most recent 5 years. It says May 2018 to April of 2023.
So that would be, is that a snapshot of that month or is that the 5-year period in total?
I'm confused by the report.
Right. I mean,
Okay.
that's sort of my question. I mean, if this is like a snapshot of when that is, if that's a 5-year aggregate total,
Mhm.
then my concern is resolved, right? Because, June, July, and August is when the traffic is going to hit for both of those things.
Right.
And, Iapo is becoming more and more well-known, for better, for worse, and so are you. So we've got two kind of traffic draws fairly close to each other, and I just want to make sure that that the study was at least reflective of their both being there and in operation.
Well, she did like
At the level they are,
last
so
time. And then
it's-
the study that was done in October was to verify the estimates she had predicted
Right.
for that peak season, and she had confirmed that it was basically it was a conservative estimate. So it was actually the counts she got were low.
I'm not asking them to predict the future,
Yeah.
even though we have the planning condition and that's sort of what we try and do.
Right.
My concern was that wasn't like an October stack as opposed to,
Actually,
Yeah.
October was our busiest month last year.
really?
Yeah.
That was sort of my
She
concern
did
with
this
the
in
traffic
October?
study.
I don't see that date.
No, I was talking, I think,
Because where it says the analysis was updated for crash data, like I said, from May 2018 to April of 2023, I'm not seeing that this is a
In the third paragraph, she observed the entering and exit traffic volumes observed in October 22 were less than volumes anticipated.
right.
So in the third paragraph.
okay. Okay.
So the study on page 800, I know doesn't look that thick, but that's the number on the bottom of the page. Talks about a series of Saturdays where they checked out kind of peak traffic. Do we know what month that occurred in?
So that was the original study.
That was the original study.
Back in,
Okay.
in,
So you redid that study. So it's probably,
and that was,
I'm not seeing a similar chart for that. Was there a similar chart to that in your redone study? I mean,
the study she did was just the counts of what was coming in and out of the winery.
so it was just through your driveway? Okay, so it didn't count road traffic. It just
Not
counted,
in the October study.
it just counted what you were doing,
Yeah.
not what was going up and down
Based on
Mountain Road.
prediction down Mountain Road. Because the Mountain Road was a study that was done originally to
Right.
count total traffic coming up.
Okay,
And,
so yours wasn't a repeat of the original study. Yours was driveway traffic.
Just to verify the counts that she had. Yeah. Of course,
Okay.
I can't answer for her, but.
Okay, so this was a parking demand study for your facility, not a traffic study for Mountain Road.
Mhm.
Right.
Okay. Because I was reading, you talked about, I think I was reading in this one where they talked about the traffic up and down the street and the accident data, or the lack of accident data on the street. So I was conflating the two situations there. One was state police, or state and town police traffic data for accidents on the road, and the other is basically people coming into and out of your winery.
I think it's
Right.
within a.
So it's not really a flow study for Mountain Road, it's a flow study for your driveway.
The most recent one.
Right, okay. But the one in 2008, was that, I mean, is, the one with the Saturday chart with the dates, was that,
That was done last.
right, was
before
that
we
your
got our first
driveway or
one.
was that
No,
Mountain
that was the road.
That was the road traffic,
Yeah.
okay,
Without
okay. And that was an October study.
no, not the original stuff.
When was the original study? Do we know that?
Well,
What would have been in 2021?
yeah.
Right.
It says November 21 traffic study assessment.
November, okay. Okay. All right. Do you have any comments on the traffic study before we move on to the maps or questions?
Nope.
Okay. How about on the phone? Any questions on the traffic study?
No questions.
Okay, super. We will then move on to the map. You want to pop up and kind of explain onto the record what we're doing here?
Well, we're not changing anything. We are just what happened when we got our conditions of operation
Right.
last year. They established a limit of parking at 30 cars,
Right.
and our lot, as this study will show, actually holds 122.
So you're not structurally changing the
We're not
lot?
changing anything.
Okay, the lot stays the same, you're just adding,
We're just demonstrating.
just striping some more of the lot for actual,
Well,
Yes.
it's all
Parking.
gravel, so
Okay.
if
No
it's striped,
striping?
it disappears. But basically demonstrating it can fit that many.
okay.
The other conditions were relative to acoustical music versus amplified music.
Right.
Whether a food truck is allowed or disallowed. It's just clarification of those conditions that were made on our.
And what
updates.
are the clarifications you're seeking on those?
It would be allowed to allow food truck. Clarify the fact that it would be allowed food trucks, but without generators, right? And without.
That's one of the conditions.
Right.
Food vendors
So we
are
allow
allowed
caterers.
without generators.
Right.
Okay.
And then acoustical music. I mean, we have virtually 100 acres, and if you have music that's not amplified, nobody can hear it. Honestly. So we're not looking to exceed the noise limits. Obviously, we're going to keep within the noise constraints, but the music would be held in the middle of the property. It's virtually you're not going to hear it beyond our property lines. Not with over the 35 decibels anyway that's required. And then the other condition, food, was the tents. Just to clarify, our conditions say no tents, and it wasn't very specific in that regard. So we said, well, no tents beyond 12 by 12 in size, because some people might want to bring a pop-up or something to shade themselves. So we just wanted to clarify that in our conditions.
Okay.
So
So you're still not looking for like large venue tents, you're looking for people to come in and kind of do the tanglewood thing, sitting on the lawn under something, keep the sun off of them.
Right.
Or the rain, depending on how well things go for the
Exactly.
event.
Yeah, it's just clarifying those points.
Right. Now, was there a lighting plan for the parking? Or is there a lighting plan, or was there one originally?
There was an original one,
Okay.
which we're not now. We are changing those lights in the background based on When we originally got the permit, Jen asked us to change the front two lights, which we did. And then we lost a few trees due to ash trees. And what had happened is now some of the lighting in the parking lot is visible because our screening is not, because the tree lost our trees. So we're in the process now of replacing all those, the parking lights to be compliant. What's it down?
Yeah, the
dark skies
the dark skies lights, the shoebox things that kind of, right, yeah. Okay. Do either of you guys have any questions?
For the music, you're saying, you mentioned the need to amplify due to the size of the property. You have here permitted during tasting room business hours. What are those hours that the music
It's stated in the regulations. It's basically 12 to 8 on Thursday, Friday, Saturday, and 12 to 6 on the rest of the week.
So outside that, there's either no music or no amplification.
Unless we have a special event, and that would be outside this. The tasting room would be closed. Correct.
That'd be special use permit.
Yeah.
Right. Okay. Anything else? Any questions from the phone?
No questions.
Okay, great. All right, just glancing through here. Any staff comments or concerns?
I'm not really sure if
Okay.
I don't really understand the traffic study,
Right.
but again, as Mark said, there's already that much parking there, and it really
Right.
might be something for the zoning commission to scrutinize a little more thoroughly. I'm not,
Right, I mean, that was kind of a concern for me as well.
because, their original approval,
Right.
where they had said, well, we've got 35 parking spaces and this is what we can accommodate. Not that you have only 35, that, accommodate. for the
You're allowed to
tasting room.
use 35 is what you're saying.
Exactly.
Right.
So I think, my concern would be similar to your concern about an actual traffic study. They were just counting cars going in.
Right.
And it
Which
was
is different-
November.
Which is different than the early study, which
Right.
counted Mountain Road traffic.
Right, and it
And we
was.
don't know the date of that one.
I just looked it up, and it was submitted in the fall
Okay.
of 2021, I believe. Let's see, traffic impact. Well, the date of their memo, I don't know.
We don't know when
It
the
was
study
November 15th, 2021.
Okay.
Let me see the dates that they actually did it.
I'm gonna try. Yeah, it was 11:15, so it would have been done.
Let's see.
You might have the
Again, I'm
original
not a
stuff.
traffic expert, so reading.
Well,
the
neither am I.
report.
That's why I
Trip
like,
assessment.
but I like to
combined with
compare apples to apples.
2022 value, I don't see in here the specific dates. This was a concern of mine originally. The traffic study. Again, not being an expert on traffic studies, but reading it, I was concerned with that they were only looking at the tasting room, and this. There's certainly more traffic than just what the tasting room will
Oh,
hold.
35,
Capacity.
assuming some percentage of I mean, you're flowing people through and out. It's not like people show up for 35. It's not like 35 people show up. There's just people coming in and
It's
out all
coming
the
in
time.
and out.
Right, I mean, there's a rotation of that.
Mm-hmm.
There is.
Right. Right.
But there's also passive recreation there.
Right.
And as you said with IAPO, like the months that, maybe.
I mean, in some ways, there's almost a synergy between the two operations, right? I mean,
There is, and we're
but-
actually hashing that out.
But I mean, I think there's some shared opportunities there for the winery and the town. But I think also there's general public safety concerns and the general ambiance of the wooded neighborhood and all of that. So I mean,
They are working on the lighting plan. You asked about the lighting plan. They do have, they have submitted a plan with code compliant fixtures. They're not adding any additional lamp posts. So,
Okay.
so that and actually having those parking spaces wouldn't be a concern.
and there's
of mine.
actually no physical on-the-ground changes taking place other than changing some light fixtures to become more consistent with modern standards and our current regulations. In terms of this application.
Correct.
Right.
Sorry, I have to reject that call. I don't know. Just have to let it be.
Okay,
Um,
so we kind of have the picture at this point. Anything else you guys want to throw out you think we should be aware of in this process?
Yeah, okay.
I don't think you covered everything.
Okay. All right. So with having that discussion, let's move on to the discussion and decision section of our.
Mr. Chairman, could I be heard?
The state has new regulations which required us to take training. So a couple of months ago, I sat through some Yukon people telling me that in order to allow comments on a plan before the commission, that I need to provide notice of a public hearing and allow people from both sides to come and speak. So unless there's been some recent change in legislation that you can call my attention to, I don't believe I can.
Well, then I would ask that there be a public hearing regarding this matter, because I think it's important that the Planning Commission understand the issues, the full extent of the issues, in order to make an informed decision. I have my client here who's directly impacted. There are a lot of issues that the Planning Commission is not aware, not all of which have to do with planning and will be brought up to the Zoning Commission, but there are certainly enough issues that we think the Planning Commission should be aware of in order to make an informed decision. So we would respectfully request that if we can't be heard tonight, that a public hearing be scheduled and we'll come back.
Okay.
Thank you.
Once again, you were saying that a lot of the issues you have were zoning issues.
But a lot of planning as well. Yeah, well, we have planning issues
this
as
is
well.
primarily a zoning function, right? Because we are separate boards, the state requires us to kind of look at what they're doing and they look at what we're doing. But in terms of operationally, you know, we might make some recommendations, they can overrule us and vice versa. You're going to wind up with 2 public hearings on this if we do that.
Right.
And it seems to be a bit of redundancy in that in my head.
Well, I'm sorry.
Also, one more. Can we even, I mean, I know we can do public hearings on a subdivision of a certain size. Is this something that we can even do under our regulations of public hearing on it?
I am not familiar with zoning referral. I believe the public hearing would be under the zoning.
Right, in my knowledge of our statute is we can do a public hearing, have to do a public hearing on a new subdivision and can do a
Right.
public hearing on a subdivision.
Right.
This doesn't fit the areas that we generally have town authority to conduct a public hearing.
I think you have the authority or the ability to do so. You're certainly not required to do so, but I don't believe there's anything that says that you
I mean,
can't.
your guy coming here asking, can you show me that authority?
No, but I believe you can. You can accept public comments. In fact, you can have a public comment period at every one of your meetings. Any
For
commission
items not
can.
on the agenda. We're not allowed to
No.
address items on the agenda.
Well, but then, and
At
that's
least
where
according to
you go
UConn.
public. Then you can.
The Yukon people who the town paid or somebody paid to teach us a bunch of stuff are telling me one thing, and you know, I appreciate you're here and zealously representing your client as you should, but you know, I am at this point more. I would defer to the commission as a whole to vote on the request for a public hearing, but I don't believe we have the authority to conduct one.
I would ask that you check with the town attorney and get an opinion from him.
Well, let me poll the mood of the commission,
All right,
and if we are
fair
inclined
enough.
to do, if there's an inclination on our part to hold a public hearing, we would then certainly check with the town attorney to make sure we're within our rights. But, so in terms of the request for a public hearing, do I hear a motion to schedule a public hearing on this issue? Second call for a motion? I don't believe the commission is interested in holding a public hearing either way in terms of the opinion of the, so we don't need to seek an opinion on that one. Good luck with zoning. They have a lot more authority in this issue, and if there's significant changes, I'm sure they can refer them back to us.
Very good, thank you.
Okay? All right. In terms of a referral back to zoning, I have that apples to oranges concern over the parking survey. I would be inclined, I don't know the mood of the commission, to recommend that a survey be conducted at a time when both the winery and IAPO in terms of traffic is considered.
More of a traffic study,
No,
not
traffic
just the
study,
driveway
right, not just the
activity.
driveway study, an actual traffic study for sort of some mutually agreed upon peak usage time for up there, for IAPO and the winery as a recommendation. With that recommendation, any other thoughts from the commissioners? Okay, hearing none. Seeking a motion to refer this back to zoning, either in favor or opposing with the,
Motion to send back to zoning with a positive referral with the condition to investigate further into this parking and traffic study to align with Camp Road, Camp Iapo, and the use of the winery at a more seasonable adjacent time for those two areas.
do I have a second?
Second.
Okay, thank you. Having a motion and a second. All in favor?
Aye.
Opposed? Motion carries. Thank you.
Thank you.
Do you want these? Or whose are these? Are these ours or yours?
For yours, yep.
Yeah.
Okay.
Do you want to? I brought some in case anybody wanted them. Nope. Okay.
All right. Next item, 218 Wood Road expired subdivision plan. Would everybody like to come up to the table?
Actually, I think it's just my client.
Just your
Because
client?
he's the,
Okay.
he's the property owner. So I just want
All right.
to start off with that.
Sure.
So let me introduce myself. I'm attorney Emery Alexander, and
Hello.
you
I'm
are,
Brad Pellisier. I'm chairman of the planning commission.
Adam Van
Wingerden.
Wingerden.
sorry,
Adam Van Wingerden.
Adam. Okay, and who's on the phone?
Pat Peel.
Yeah. I'm just hard of hearing, so I couldn't hear what he was saying. All right. So during post your last discussion with my client, I talked to Carly and Alina, and we were kind of hashing out, well, why is this even going further afield, and whether or not the lot itself meets the requirements to be a building lot. And then from there, it would transfer down if it was my client who was going to build, or a potential buyer who was going to build, or a buyer would build. Then it would go to the next authority, right? So that person, either my client or the buyer of the property, would then seek a building permit / and a zoning permit, and all the discussions relative to drainage and all those issues that were brought up the last meeting when I was not here would really be addressed then. So during my discussions with Carl, he suggested put it back on the meeting agenda,
Okay.
and that he would like to be here, but unfortunately Carl was not told of tonight's meeting, so he's not here because he's at a meeting in Enfield.
Fair enough.
So I'm trying to just do informally, and I guess I'm trying to get my head and wrap my head around what regulations does this lot not meet to be a building lot that then either my client or the buyer would then file a building permit or a zoning permit.
Okay. Our perspective is subdivision was created,
Yep.
right? And there were 8 lots on this subdivision,
Mm-hmm.
right?
Yep.
And then the subdivision didn't happen,
Sure.
right? Except for it kind of did,
Sort of did.
right?
Right.
I mean,
You have 2 lots, so you have my.
there's 2 lots that aren't a part of the original piece anymore, right? So I had 1 lot that was this piece of pie, and now it's this piece of pie with these 2 pieces missing and no real formal proper. There's no subdivision plan.
Well, so let's go step back a minute. So when my client bought his property, the subdivision plan was in effect, right? Because it didn't expire, in my understanding, until 2007, March 14th. It was approved 3/14/02. That's
It was never filed on the land record.
All right, but
Well,
the
I mean-
plan itself, I'm just going by what I saw on the
Right.
plans. I'm just trying to wrap my head around this, okay?
The plan existed.
Right.
Nobody's denying that the plan existed at one point in time.
But my client bought his piece of property during that 5-year time
Right.
period, right? And then another piece was sold by the Wood Estate in 2007 when no plan would have ever existed because it would have been expired, right? So I guess I'm going to go back because Carl and my discussion was what regulations does this lot not meet to be a building lot.
In order to make a subdivision, you're required to file a subdivision plan. We meet, the town staff reviews it, they approve it.
He has a different opinion than that. He said to me, and I guess that's what my question is as well, is what regulations does it not meet to be a lot, a building lot, to be a lot? He has the required frontage,
Right.
he has the required square footage, he has the required depth, and that's what you need to be a building lot, correct?
And you need a subdivision plan.
Okay,
Otherwise,
so who's
people-
responsible then for that subdivision plan when it was in effect when my client bought? Then the Wood Estate sold another piece technically that the Charlans should have never been able to build a house on because there was no subdivision, right? I'm just trying to figure this out. Who's then responsible,
Okay, well,
right?
I'm sure people buy into subdivisions all the time.
But it wasn't a subdivision when that other lot was
Okay,
sold.
that's a different issue.
Well, how can it be a different issue? Because if it's good for one, how is it not good for the other?
Neither of them are valid lots. The subdivision was never filed on the land records, and Carl and Alina bounced it back
Right.
to the planning commission, and he said to
Okay.
Dan Parisi, the land
Here's
inspector, that
the problem,
it was
I
up
think
to the
probably
planning
the best
commission.
answer for you, or at least in my head, I've been trying, listen, this is not normal land use business, right? Normally, people file for a subdivision,
Yep.
they may sell some lots before they've met all the conditions because they gotta get construction equipment in there and all that. So it's not unusual for people to buy lots into a subdivision before it's completed and gone over all the hurdles.
Mm-hmm.
What is unusual is for somebody to come in, buy part of the subdivision, and then have the subdivision go away,
Mm-hmm.
right? But the subdivision is a single unit. It goes away, right? It's kind of like you're almost like buying a future of the subdivision. In terms of the other piece of property,
How do they get a building permit?
we can only act as a commission on issues that come before us. That may be a town staff concern, a building department concern in terms of people checking records. But that's, when things come before the commission and we're made aware of them, we have to act on them. You know, a cop sitting on the side of the road can let 12 drunks drive by. But, you know, somebody comes over and says, you know, this guy drunk, you gotta pull him over, right? Somebody brought this issue before the commission, and we're now aware that this whole thing is basically out of compliance, right? And we have a duty to the community to respect, you know, the intent, the letter of the law in terms of this is our subdivision regulation, this is how it gets cut up, this is how it happens.
So does Mr. Charlin need to remove his house from that piece of property because it was never a subdivision?
I don't have that question before the commission at this point. What we're dealing with is his.
Well, but it all flows together, right? You had
Eventually
Attorney
it
Parks
does.
come
I mean,
in
look,
and talk
I'm
about.
not saying you're not asking a fair, legitimate question.
Mhm.
I'm saying that in terms of the business that was brought before this commission, there was a challenge raised as to whether or not he had a legitimate building lot. And when we sat down and looked at the subdivision plan that went away, it went away. It ceased to exist. Right? When you're buying into a subdivision that isn't completed and finished and signed off on, you really are sort of buying real estate futures and this being a usable lot, right? I mean, your client bought a lot that had, you know, obligations to the rest of the subdivision that didn't have frontage attached to it. And when that went away, I mean, I know you guys went
We
to
did
court
have
and sort of
frontage.
tried to clear some of that up.
He was
No,
referring-
it was-
referring to the
Right.
drainage.
Yeah.
Yeah, there was pretty frontage because there was a lawsuit that was brought, and I think when the developer went belly up, right, there was a lawsuit, I believe, by Joff Limited Partnership and the Wood Estate, and they determined who owned what. Then when my client initially came in, he was told he didn't have the frontage. So then there was a subsequent lawsuit or negotiations with Judge Teller, which resulted in the title company then buying the required frontage from
Right.
the woods.
Right.
Okay. So at that point, he had the required minimum frontage, square feet, etc. Right.
Right.
So you've been able to build on it at this point. And at some point, somebody in the town determined he had a buildable lot because he's been taxed on that
Right.
since 2011.
Right. And as I explained the last,
Well,
I
a
think
buildable
we-
lot, let me just interject, please. A buildable lot has to be, you know, the zoning, the soil and erosion control, etc. in the sanitarium. So I think, and I'm not 100% sure because I was only briefed on this by Dan Parisi, who's
Who wasn't here then
out
either.
right now. He wasn't here then,
Right.
and he's out now. And I wasn't here then. I believe that there are drainage requirements that need to be put on that was on the original subdivision plan, and I don't know the civil part of it. It might be a civil matter as to who is responsible for putting in the drainage requirements.
Well, let's go back here. How can you say there's any drainage requirements
Because
when you're?
it was on the plan.
But
and
hang on,
because
but
it's
this
a
plan,
benefit.
but hang on. You're telling me this plan is
I'm
non-existent.
going to
so-
agree with you on that one. The plan doesn't exist. The drainage
so the
requirement
drainage
was put
doesn't
in for an
exist.
8-lot subdivision in order to determine whether the drainage is needed for a smaller subdivision that would include this lot would have to have, town staff
Well, he
reviewing.
should submit a plan. He can submit a site plan showing the soil and erosion control and a proposed house, and then that's where
But-
Joanna would look at it, and
But-
that's where
but
my
we're
commission
still kind of
drainage.
leaping over the question of when does this, what happens to the subdivision process? I mean,
I
if we
understand. She's
do
questioning
this-
if it's a buildable
right,
lot.
Right.
Well, I'm questioning both, right?
Right.
I'm questioning, is it a buildable lot, and why should my client have to undertake then a subdivision process when you have another house here that there was no subdivision allowed at that time either, was allowed to build, right? So that's where I'm having the big
Look,
issue.
I think-
This is,
Hold on,
This isn't a
I
public
just threw
hearing.
George out of here for asking for a public hearing, so is this, this is on,
On
Right.
my client's interest in
Yeah.
218 Wood Road.
right. So, I want to treat everybody in here fairly. So, the last time it was sort of both properties we were talking about, right? Or
I mean,
No, it was just
My
218
perspective
Wood.
is we're talking about the subdivision
All right,
plan,
All right,
and I think everyone's
if we're going to
involved.
talk about the whole collective thing, I guess there's a party missing, but
So-
we had
so
open
are we
last
talking
time.
about the subdivision
Was
plan?
this the same agenda item we had last month?
Basically,
Come on up.
that's what it said on the last month's agenda.
All right, because you were,
And he spoke.
right, he was at the table last time, so
So-
it's, our best chance of settling this is to look,
Your client had the opportunity to spoke at last month's,
Well, 'cause
meeting.
he
If
requested-
The agenda item was
Right.
this, no.
This was 218 Wood Road. That's
So
his
it's all
property.
been on there,
Right.
everyone's been able to talk about it, and we're just trying to come to a
Okay.
conclusion.
but here's the thing. My concern as the planning commission, I think our concern as the planning commission is, I know there was a whole process around that, but basically what happened here is what keeps somebody from coming in and just sort of selling somebody an acre or 5 acres or whatever the buildable lot is without going through the subdivision process and having them show up and say, well, I have a buildable lot. Because, and now we lose all control over what we're responsible for, the orderly development of the town. That's the
And I
duty of this
understand.
commission, right?
I get that, but
So-
this has already happened, right? Somebody already came in and said, hey, I'm doing a subdivision. Now it's expired, right?
Right.
So I think
You didn't know.
my suggestion would be is that I think Attorney Lena needs to weigh in on what happens when a subdivision expires. Okay?
well, there was,
And somebody else is then allowed to build a house with that subdivision being expired, right? And is, quite frankly, my client grandfather,
Look, it was my understanding that was a pre-existing
It
house.
was a pre-existing house.
That
but they
was- that
still
was there.
sold the property, right?
Right.
In a subdivision that didn't exist,
Right.
whether it was pre-existing or
Right.
not.
Look, I have the same problem with that piece of property I have with your piece of property. I think I was pretty clear last time that I think all 3 pieces of property are tainted by this process, right?
And so what happens though legally? I guess we need to know. And
so
that's
may-
the big
May I
question.
speak? I've been raising my hand.
Well,
And I think in my conversations with Attorney Landolina are of a different nature, or his responses of a different nature,
okay,
and I
would you-
really
could
thought he
you-
was going to
could
be
you-
here
Could
today.
you share with us what your interpretation of his response was?
His interpretation of the response was is if he met the regulations as far as a buildable lot,
Right.
then it would be up to either my client or the buyer of the property to
Right.
then come in and seek a building permit. I'm looking right at my notes here from Carl. And seek a building permit, and then that's when all the drainage and all the other
Right.
issues
But
would be
doesn't
discussed.
the subdivision process start something becoming a buildable lot? Isn't that the key to the door to becoming a buildable lot?
Not what I'm seeing online, and I guess maybe you can refer me to that what part of the regs, and then I'll have a further discussion with Carl about that. Maybe that's why Carl needs input.
I mean, he might need input. In my opinion, how we function now, I don't know when that other house, if it was existing already, or if
It was an old house.
or built, rebuilt. If someone comes into our office the land use office and asks us, this is a vacant lot for sale, is it a buildable lot? Well, we would actually go look for a subdivision plan just because that's the start. And we would say, okay, Russo did this subdivision plan, so, you know, they got to prove that this is where the house location can be, and this is everything that's needed to be done. Have them revise, and you have to submit your own site plan for that one lot, showing, you know, where you're going to put the septic, have your soil
Right.
testing done. So,
And I
so that's
agree
how you
with
get
that.
and zoning it where your house is, and that's where we call it a buildable lot. I can't say who reviewed a site plan, whether it be for wetlands or drainage or erosion control for the other house. Even if they rebuilt the house, if they demolished it.
Well, they would have to
rebuilt it.
create a separate lot for that, right? Because it's a whole separate lot that has a different address, it has its own lot, it has its own dimensions, right? So how did that become a separate lot from the big whole rest of the piece, right? Because it was part of the whole rest of the piece.
Like
I
I
mean, it
said,
almost sounds like a civil matter, in my opinion.
Yeah, I
I mean,
mean,
all
the
three
one
of
that
the-
has the answer to all this is me, but I haven't been able to speak
Okay.
yet.
Well, quite frankly, I'd rather have the town attorney who has the answer to it.
well, I'm not
than-
sure. I'm not sure we're answering this tonight.
Right, and I
But I-
agree.
You can't. So here's the thing. The statute gives the town the ability to have a planning commission and pass regulations, which this town did. The regulations are everything that your board is able to do. And what's being requested here to figure out what happened as a result of not one lawsuit, but about a half a dozen lawsuits, is beyond your scope. It's a very simple thing. She's asking you to figure out, like what a town attorney maybe might figure out at a planning commission meeting, but you don't have the authority to do it.
Well, initially Carlos said have the planning commission put it back, asked to have it put back on the docket, and I would like to be there. Unfortunately, when I emailed him today, they said, hey, Carl, just make sure you're coming tonight. He said, no one informed me, and I have a meeting in Enfield. So,
Okay. I mean, I had a brief conversation this afternoon with Carl.
okay.
And basically, when I expressed my view that all three lots are equally tainted, he didn't tell me I was wrong,
Okay.
right? Now, is there a separate issue with that third piece of property? Absolutely. But kind of to your point, that's not the issue for this commission. Right?
It's out, you're
That
beyond
there,
your.
can the town take some action to redress the illegal I mean, look, the parties who created this thing aren't here. So we all kind of have to try
I
and.
think you lost the person
Yeah.
on the phone.
You did.
Let me get him back. I'd like to do this with a quorum. Please.
Pat,
Yep.
did you hang up on us?
I don't think so. I don't know what happened.
Okay.
All right, so we still have
All
a
right, we got
quorum,
you back.
so
We
we're
haven't
still
talked about
legal.
anything.
All right. Yeah. Listen, this is a mess, right? And in some ways, our responsibility is to the town is to have orderly development, to meet our subdivision regulations, right? When things go awry beyond that, yeah, there's probably a civil court solution to this. There's probably, I think I threw out last week, the suggestion that you've got 3 non-conforming lots. If somebody takes what's probably already existing drawings, because I've seen things that look a lot like it, and submit them as a subdivision application, we had even talked about like waiving the application fees, and do the simple 3-lot subdivision that's been created here and make everybody legal, you know, in my head, that's sort of the easy way out, because now everybody's lot is now and for the future on record and proper. Because, you know, you guys can settle this in litigation.
Yeah, well,
What
so
happens the next time some neighbor gets upset about something? Now, you don't have you didn't meet the regulations, you got it by judgment. Can somebody go back and get a future judgment throwing the whole thing out?
that's my point.
I mean, you know,
That's
how far-
about how it was created.
Right, I mean, I want, as the commission's perspective, my interest is in seeing something that preserves the town's duty to have orderly subdivisions and a process for which town staff gets to review things that happen before they do. And have all, when we say it's a building lot, we have some document we can point to that says, yes. It's like, you know, like Jen mentioned, when you look at the lot he purchased, there's the drainage requirement that's on that plot plan. There's, I think,
That may no longer be in existence when you're no longer, that requirement may
On a
no longer
3-lot
be needed.
subdivision, what you need is different than what you need on an 8-lot subdivision, right?
Mhm.
And I think you raised the idea, could you do more than 3 lots? And I don't know how you guys balance the economics of that in terms of the cost of development, things like that. I don't know, the financial end, not my problem, fortunately for me, right? But, you know, the easiest way out of this for you guys, in my head, and I might be wrong, is to just do a 3-lot subdivision with the 3 parties involved, come up with something that the town can review and determine what are legal building lots, and move on from there. Yeah, you can guys go to court and probably get some lawyer to tell us that we're wrong and these 3 are all legal lots, but where does that put people down the road in terms of it's a judgment as opposed to going through town practice, and you know, what happens with that and how that affects I don't know. I mean, these are all questions that you guys can answer much better than I can in terms of what sort of problems occur down the road with this. In terms of a nice, neat, orderly package for going forward,
I think if you get a judgment from a court, then that would be binding. Right?
you can get somebody to tell me what to do. Yeah,
But I don't know if I
I'm
want
not
to do
arguing
that.
that
And
point.
it's a lot of,
Is that
aggravation, a lot of
the
money.
quickest way? Is that in the best interest of?
it may
You
be.
know, and you get a judgment on him, and that's fine. Now I still got 2 pieces of property that we got to worry about, and we'll be talking to John more, and probably some other people. But you know, for the problem you're bringing to us, you know, you guys can litigate this, or you guys can work together and come up with a subdivision plan on the 3 pieces of property. No,
Well, my
we're
cons-
volunteers. She's town staff. You guys can come back to us as often as you want. But I'm happy to see you. I enjoy talking to you. Yeah, I mean, this is kind of interesting stuff to me. That's why I'm here. But I'm not sure. To John's point, we're a one-trick pony. We do subdivisions, special use permits and things that sort
Look,
of
the
attach
only
to
reason
it.
I
but-
came back is based
but-
on my conversation with Carl and
Right.
said, hey, go back and have a further
Right.
conversation, because my client didn't have the ability to have me here.
Sure, and I appreciate.
So-
I mean, and you know, I was kind of surprised to not see him represented by counsel and.
Well, because I had a conversation with Carl before
Sure,
that, and he
okay.
said, look, this is kind of going to be an
I mean,
informal
I've talked
discussion.
to Carl a couple of times, and yeah, it's sort of an informal discussion because we don't have a plan before us,
Right.
right? I mean, we're not acting on a subdivision plan. We're not deciding anything with this, right? Because there's nothing before the commission for us to decide. This is really informal conversation.
Well, you're
But-
deciding there's nothing to decide because
Right, I mean,
you get
the-
the email from Carl in March, right? You remember it?
Yes.
The email that he sent to your client saying the decision of whether your parcel is a building lot is best decided by the planning commission. Your parcel is transferred in violation of the conditions attached to the subdivision approval. These
I have that,
conditions
but I had further discussions after your last meeting with Carl, and he gave me a different
Well, we don't
opinion
have
than
any
you
of
would.
that. So, and
I can more
yeah.
than well show them to you, share them to you, and in fact, there was other
Because his
emails.
decision here said that it is not a decision for planning staff or the town attorney.
It's the commission.
And that's why the commission-
But the commission has a scope of practice, right? I mean, that's probably the wrong term for it, but we have boundaries of things that we do, and we're kind of bound to stick with inside them. And you know, resolving the purchase of real estate from an unfinished subdivision that went away is kind of outside of our pay grade. Right? I mean, there are people who go to school a lot longer than I did who kind of sort these things out. I'm doing the best I can with what I got, but my regulations are really just the subdivision regulations as it applies to this case. And were things done wrong other than the sale of this piece of property? Absolutely. I don't think anybody at this table is arguing that this was done properly.
Well, I don't
They're
think,
not
no, I
necessarily
don't
at
think the sale
fault,
of
but they
my,
recognize that this was not done properly.
I don't
there's
think
no
my
dispute about
client's
that.
purchase of the property was wrong, because quite frankly, it was during the time that the subdivision was approved. Right? My client purchased it, I believe,
Right.
in 2003.
It was approved with conditions, right?
Right.
Those conditions were never met.
But that's
So-
not on my client either, right? Because he wasn't the one who was responsible
Well, he
for
kind of bought into that. I mean, when you buy, he didn't buy a finished subdivision. He bought a
lot.
Right. He bought a proposed lot in a subdivision. Because until it meets the requirements, it's still a proposed subdivision. Am I correct about that?
Well, you're correct. If he bought the lot, came in a year later, I want to build a house on it, we would have noticed, okay, the fee in lieu of open space has to be paid or wasn't paid.
Right, and that
Right,
would
the
right.
Mylars weren't filed, so it would have triggered knowing that it was not filed.
Right.
So,
And that would have come back when on
Unless
on the developer, quite
unless
frankly.
staff or a title searcher didn't catch
Right.
that, and the staff approved the building permit and he built the house, he'd be in the same boat as the other property.
Look, if I buy pig futures and all the pigs die, I'm out money, right? You bought land futures essentially in a subdivision. There was a proposed subdivision with conditions on it. That was all public record, right? And he bought into a proposed subdivision with unmet conditions, right? And
No, he really bought a lot with an attorney who represented him and purchased
Okay.
a lot that committed malpractice, right?
Okay, so,
I mean,
look,
it's
if
a little different than
we
buying.
can talk about due diligence versus,
Right.
detrimental reliance, but again, I don't have a road. That's really a guy with a road question. I mean,
But the
it's a
problem-
fair question. Obviously, it's a fair question.
Mm-hmm.
But, in my head, this was a proposal that never came to fruition. Right? It was buying into a future event that never got to where it was supposed to be. Did he understand that? I don't know. I'll even say, okay, he wasn't aware of that. He was taken. We're not the remedy for that. Our goal, our job, the primary mission of us sitting here is the orderly development of land in this town, and that really requires subdivision, staff review of what's proposed against the regulation, and make all of that happen.
So
Right?
the other suggestion that Carlin said is instead of a 3-lot subdivision, that my client go for a single lot subdivision. Because honestly, I don't know if we're
Right.
going to reach an agreement on a 3-lot subdivision. Because my understanding,
So you-
John can
I
correct
mean,
me if I'm wrong, is that his client doesn't want this piece of property sold.
No, that's not my client's position.
Okay.
Okay.
Is that a possibility? I guess I just need to know my
So-
options.
so-
One
so
lot
I'm
or
thinking-
It's stuff that happens when people talk, and that hasn't happened.
Right.
And we're here wasting this board's time, and
Well,
I don't understand.
John, you know what? I asked
I
to
mean,
come in
can
here
you- can-
informally and have a discussion with them.
Can you do?
so.
Can it be a one? I mean, it's essentially going to be a 2-lot subdivision because it has to have come off of something. But there's an existing plot plan for this.
I think you suggested it because
Right.
the other lot's there and this lot's here, and then
Right.
we weren't talking about the few lots that were in between.
So
the
what
two
you're
lots.
asking is, can the town take? Because I know there's this. We've got this piece of property cut out with this.
Right.
Can the town look at that has basically coming off of the single large piece and review this as a 1-lot subdivision, or basically a cut off of the other piece?
I don't want to convolute
No.
the situation, but I'm wondering, was there ever a free cut? Do you know? Has there ever been? They already had their
Yeah,
first free cut.
This goes back to the
There's a
King's-
lot of
This
history
goes
here.
back
That
to
would
the
make
King's
it
grant.
simple.
Somebody's
There's people
cut this
here
thing.
that don't know the whole story.
That would make it simple,
But it's
of
not
course.
it's not your
Look,
purview.
I mean,
to
if I
get
take
out.
if you take that piece of property and go around it, it's your family, your family, your family, your family. Somebody bought it for your family, your family, your family. I mean, that's been cut a few times.
Okay.
But I mean, look. In terms of the fees, in terms of what we get, look, I mean, I just want the mess straightened out. Let's do this. Can we run by Carl? I'd like to sit down in the conversation when we do that, but I'd like to run by Carl. And if you object to this, holler at me now. All right?
I don't know what you're saying,
But my thought is, if we were to look at this as becoming a subdivision off of this large piece of property, and look at developing this piece of property, considering its effect on, would we allow this subdivision to occur? Does this meet the standards for a building lot? Right? And decide on this piece of property and determine whether or not that was a legal building lot if they were to cut that off from the large piece of property, right? Considering its effect on both.
So when you say this piece, you're talking about my client's piece
Talking about your client's piece being
From
cut
the
off
big-
from
the big piece.
being in paper cut off from the big piece, right? And as we always do, if you're doing a subdivision, we look at, okay, what's the downstream effect of the subdivision, right? So we would look at that in total and see if we can legally to use the Mylar that he submitted, or the plan that was submitted for his piece of property.
Well, that's got other lots on it, so I think. that
No,
you-
but I mean, look at this piece, but look at the other in its entirety, has one lot, right? I mean, because that's what it is now, right?
Okay,
The
but-
subdivision expired.
But we've decided that the drainage might not be an issue if the other lots aren't there, correct?
Right, you're looking at this against the big lot.
Right.
Right.
So,
The subdivision's gone,
so I'm concerned.
but this exists.
Well, I'd have to have, Joanna, our erosion control agent,
Right.
or our sanitarian, or
No, everybody would
engineer.
have to look at it. It would be like somebody was coming in with a subdivision.
Right, but, I mean, you'd be approving something that says you have to have the drainage, is my point. I'm saying.
If it has to have the drainage.
Do
'cause
we
it's not-
have the engineer, whoever it was, whether it was Russo or do we have whoever made the plan revise it, remove the other lots?
Yeah, you're right, because this flow studies would have to be.
Exactly. It's going to be different.
Right.
Unless
You're
they
right.
can collectively
I'm sorry,
work
I was overly
together.
optimistic.
Well, collectively
thought it
work
was on the-
together and
I thought it was
both,
on the
and if you still want to do the subdivision,
I mean,
prepare an updated map and then file the Mylar, and then you actually have those other lots already approved, if that's what you want to do.
you're talking about dusting off the old subdivision?
Yeah.
It's not impossible. I mean, I don't know if you're interested in, you'd kind of thrown out, can you do it larger, but I don't know what your plans are.
Yeah, I don't know if we're at that point.
I mean, the plans are sitting there, right? I mean,
So
if you guys wanted to like leap
Your
up
regs
and
have changed a
take
little
the
bit,
over,
but I think it's all doable, but
I mean,
people have to
I
work
don't know.
together.
I mean, this is sort of,
So the problem is if they're not interested in what I'm hearing you saying, what I'm hearing John say, if they're not interested in subdividing the 3 parcels or subdividing that bigger parcel even more, I want to know from my client's perspective. My clients say, can we come back and do the 1 lot subdivision?
Right.
So if that
that's
means
what I was trying to figure out.
Right.
And I think, to Jan's point, we have flow data and soil stuff based on,
an old,
right.
The other lots.
Right.
And what happens is, we don't know whether or not that goes away with 3 lots or with
Just
whatever
one.
happens, right?
Right.
So that somebody would have to go through that process,
okay.
right? And,
Right.
And, it
And
would,
what exactly would you need me to say go through that process? You want my client to submit another map or another plan or?
Well, it's in the regulations. Just read the
John,
regulations.
do you know what? I'm not asking you, quite frankly.
No, but they don't.
I'm
have
not an
to have
expert on
authority
this,
on
John,
the
and you may
regulations.
be, but I'm not
please,
asking you.
let's not interrupt each other, okay? I mean, I understand that, this is outside of your norm, we're past your bedtime, you want to go for your bike ride in the morning, but
I would start with talking to Andrea.
Okay.
She's our sanitarian. She does the soil testing, for the septic. Start with her. Have her look at the old information we have.
Yeah.
Let her know what she would need, and then Joanna, our wetlands and erosion control agent. She could look at it. I'm not an engineer, so I don't
and
know.
we need to find out from Carl whether or not we're inbounds or close enough to inbounds for the
Well,
situation.
right, we can discuss that with Carl.
Right.
I don't think you can.
And then-
I don't think you can approve it with the existing plan.
Right, you're right about that.
Okay, so why don't you discuss it with Carl? And because I don't really have my client, I don't want to bother anybody or make anybody do any work that's not necessary, right? So until you discuss it with Carl and he says, yeah, you know what, it's feasible, go ahead and do it, then somebody lets me know, lets my client know, and
Now,
then we'll move
there's
forward.
another side to that is, you do have neighbors, and your neighbors have some concerns about development of the property that they've expressed. So, that's going to be a consideration moving forward too, is we might
understand,
do
but-
this and wind up back in, you guys might wind up back in court again anyway. I mean, I don't want to speak for John or his client, but
The only
we're
concern is
kind of
they
here because somebody raised some issues on this property. I mean,
I don't even know how it started.
right. I mean,
it started because my client put the property on the market.
Right.
And then he
Okay.
was told that
Got it.
somebody, and he was told the Woods, were going and scaring off prospective buyers and telling them it was not a building lot. So my client came in here to get some information. Why is this not a building lot? Because quite frankly, I've been paying taxes on a building lot for 10, 12 years now, right? So he's under the impression he's got a buildable lot, goes to sell
Look,
it,
I mean, I feel
finds
for
out
you.
he doesn't.
I had a house with a second lot attached to it that they were taxing as a building lot. The ground went like that. I had to go before somebody and say, listen, the ground goes like that. They said, oh, we won't tax you as a building lot anymore.
Well, but the funny
it's a
thing is, they
separate
weren't
thing.
taxing him.
Right.
They weren't
Separate.
taxing him as a building lot until 2011, when he got enough for the frontage, right? When he got the front piece for the town, right? And then he got started charged as a building lot.
Right.
So from 2011 till now, he
Right.
thinks he has a building
Okay,
lot,
Tax
right?
office is upstairs.
Assessor, yeah.
We're going to be going there next.
Go beat them up over that.
So we're gonna go there
And,
next.
You know, I mean, the government, we're very compartmentalized. There are a bunch of people you can yell at for this situation, all over the place. I mean,
Hey,
it's
look,
a
I get
mess.
it, but so that's what. But I'm saying that's
Right.
what sparked my client then to come down here and say, "What's
Sure.
going on?" Because I thought I had a building lot and I don't, and so
And I
then
can understand why you would think that. I mean, that's not an
Right.
unfair assumption. When you buy a building lot and there's something wrong with it and they fix it, you kind of expect it to be fixed, right?
Yeah.
I mean,
everybody else is telling you have a building lot, right?
Right.
They're getting taxed
Yeah,
on it,
I mean,
etc.
look,
So that's what
he-
sparked
he
this in
doesn't
my
have-
client.
You don't
thinking.
have an unreasonable expectation here, I don't think. You just don't have what you think you have yet.
Right.
Or, I mean, yet is probably optimistic. I don't know where this is going.
So you know what? So
But-
my request would
Let
be
me-
is you talk with Carl,
Let me talk
and
to
then
Carl.
we'll go from there.
See if we can pull this off as some sort of weird punt,
Yeah.
right? And then, you know, I don't know. I mean, it's sort of a funny subdivision. Maybe we have to have a public hearing and listen to what the abutters have to say about it.
Then the proof is in the pudding, kind of,
Right,
so
but
to speak, right?
just to be clear, I mean, we have a public hearing. We hear lots of stuff. We try our level best to go by what the regulations say.
Mhm.
So, you know, the best regulation, the best argument against this is this doesn't meet this or that regulation, and we are kind of punting on, you know, we're kind of running the line on a good day with this in terms of regulations. So, you know, a little goodwill
You only
all
have
around
certain
might
regu-
make it work. I don't know. That's all I can say on that matter, I guess.
No, whether it's a drainage issue or not is all going to go by the regulations,
Right,
right? And with
right.
the town input. So
Yes.
the proof will be in the pudding, so to speak.
So
like
let's
that,
set
right?
we'll set a time when we can talk to Carl,
Yeah.
preferably in the not too distant future, go tomorrow. And
Out on Fridays.
you don't work Fridays, okay. And I was going to work Friday, so that solves the problem. Neither of us would be
And
available.
honestly, in the meantime, it may be me doing a little bit more legal research and have a little more conversations with Carl if there's
Right.
some type of other case law that addresses
Right.
this issue.
Yeah, look,
We're
I
going
mean,
to have to look
if
at
we're
that as well.
completely off base here,
Sure.
I'm willing to learn.
Mm-hmm.
You know,
I'm not 100% sure, and so like I said, Carl and I were having this basic conversation, and he said,
Right.
you know what, it may help if I'm there, and so I thought, fine, let's put it back, you know, one at his direction. So there's a couple options, and we can explore them.
right.
And,
I mean,
Is that the Mylar of the subdivision?
No, these are
this-
new ones.
This is a different one. This is the next problem. This is a lot. This is a subdivision that we've approved that we just had to sign off on.
It's not the next problem.
It's going to work successfully, right?
We're going to make sure they file it.
Yeah.
yeah, because it was never recorded. So he's asking why he has a plan that said it was unconditionally approved.
Unconditionally approved.
It means there's no condition. Well, but I'm surprised it says that because he is able to
Is it
finish.
signed?
It was signed. It was signed. Town sanitarian, town engineer. No, I don't think you. I don't know who this
There's going to
is.
be a signed.
There is.
Yeah, right here. Those are the ones that are missing.
Nope,
That's the one. That's the
Right
one
here.
we got the
March
strip of land
14th,
and
March
submitted.
It says town approval was expired March 2007. It was approved in
Yeah, it
2007.
expired because right, it was expired
Yeah,
in
it says
2007.
unconditionally approved.
Right.
Yeah, and the condition, it was revoked. It expired.
It wasn't filed on the land records.
I understand that, but that's what I.
Well, it's not that it's not filed in RAM records that makes
No, I
it
see the
expire. I thought
term
you had
for
to
that,
complete
don't
the
I?
building within that 5-year time frame, and
No,
that's what
not
makes it
happening.
Well, I have
expire.
to file
right?
the Mylar on the land records within, I believe, 90 days of approval.
Well, this guy didn't do a whole bunch of stuff that he was supposed to do now, did he?
Plan reviewed and found
Everybody
in
else is
general
suffering the
compliance with the
consequences
subdivision
today, right?
regulations has amended and approved by the town of Summers.
Right, but then
Right,
there's
so
statute
the plan is in
requires
compliance.
filed and-
The,
Yeah.
the plan was approved and is in compliance. The plan never happened.
Right.
We approved this. This didn't happen.
Right.
Right.
I get it.
Right. That's
get
why.
it.
That's why it's not. Right. I mean, this is the drainage thing we were talking about. That didn't happen.
Right, but neither
There's
did.
a frontage thing here
drain-
to allow some drainage in here. That didn't happen. Right. So that's why this is approved. This is what's approved.
Right.
Right. Since this
But
didn't
the whole
happen,
thing expired in
Right.
5 years.
So,
Right.
but
And
the
then-
question is, do we really need
Need
this
this
drainage
without all these.
without all these?
Correct.
We're probably not going to be putting in Cape Cod. If we're not probably not going to be requesting curbing and drainage pipes down here, right? I mean, I don't know that. I mean, they'll have to look at that. But
Yeah, the only thing we're gonna keep is this 25-foot ravine that takes the water up the mountain and sends it back here.
right, well, they'll look at it. That's why we got to have the town. The people who have degrees in this stuff, which I don't have. Look at it, look at the slope, look at all of that stuff, and come up with something
Which
that's.
is the only house that's here? The other house that's here, which one is it? Is it 7
This
or
was
8?
the one that was supposed to be demolished, but it didn't.
They didn't
See,
get
that's
them
another
all.
thing that didn't happen.
So
Where's,
one of the
where
possibilities
does, where
is
does
a one lot subdivision.
Charlin, which lot is Charlin's though? Is this one here? So this is the only thing that's there besides your lot, and then the rest of it's all one big piece. Right, so all these lots that are no longer lots, all this property is still here.
Right. As far as I know, that's somebody who's considering houses in general.
So if we go for a one lot subdivision, where's the
But,
problem?
Well, you could also go back to Palmer. Okay. All right, so let's start the conversation with Carl.
Okay, so you did it? No. Okay.
So then somebody will let either my client know
I'm
or
always
me know.
afraid when
or
they start
Carl
talking
will
about
let
my
me know if
signature's
somebody
going to be
knows.
on.
Yeah.
I've been around long enough for that to happen.
No, you were
That was
around then. You were around then. I don't know if you were the chairman. You were around.
I was the chairman, I think, when Carl left. So I
Yeah.
was probably around then.
Yeah, you were around.
Do I need to sign something
I didn't
else?
sign it.
I didn't sign the top one. That's 'cause I
All right,
didn't- yeah,
thank you for your time. Have a good evening.
Okay, thank you.
Oh, up here.
Thank you.
Oh. You didn't want the top line,
Save it for you.
huh? Oh, I thank
Sure.
you.
We'll
It's
keep
amazing
everyone
how small you
posted.
can make Van Wingerden.
It is weird. I'm just like scribbling on there. I think I'm concerned about that happening in the future, so let's try to make it
Yes, right.
legible.
So nobody can subpoena you.
Yeah, exactly. That's not me. It's clearly not my last name. Motion to approve minutes with adjustments submitted.
Okay, you have a second? Second, all in favor?
Aye.
Opposed?
Motion to
Opposed?
adjourn.
Have a second? All in favor?
Is Pat still there?
I don't know, but
I
I'm
am.
thinking.
You're seconding these
Yeah.
motions?
Second.
Okay, good, you're still here. I was afraid we'd gone off the record at some point.
Okay, motion
We
to.
are still a quorum.
Yes,
We're still a quorum.
still here.
All right,
Did you adjourn?
yes we did.
Motion adjourned.
Pull the plug.
Thank you, Pat.